Subject: Law of Torts.
So, today we will cover the following topics:
What is tort?
elements essential of torts, act or omission, legal damage,
Which includes injuria sine damno, damnum sine injuria, mental element,
includes intention and motive, malice,
remedy.
difference between tort, crime and contract.
Let's start with an example.
Suppose a girl is playing loud music at late night. As a result, the neighbor is getting disturbed while recovering from illness, due to which he suffered discomfort and medical expenses as well. This is the example of one of the tort, that is, nuisance.
Now, the injured party brought the civil action against the defendant. Here in the case, the injured party has suffered discomfort and medical expenses, so the court may grant monetary compensation.
The person committing a tort or wrong is called a tortfeasor or wrongdoer, while the person who suffered the injury, loss or damage is called the injured party or plaintiff. What is tort?
Performing an unpredictable, wrongful, or tortious act instead of reasonable behavior. Tort has been derived from a Latin word tortum, which means to twist.
Let us discuss a definition of tort. Tortious liability arises from the breach of duty, which is primarily fixed by the law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages given by Winfield.
Let's see elements or essentials of tort. So the first element is act or omission.
Now, what is act? It refers to doing an action.
But the action could be wrongful or rightful. Let's further see omission.
Failure to do an act as whole is called omission.
Let's move on to legal damage. It consists of wrongful act or omission, violation of legal right, breach of legal duty.
Next is injuria sine damno. Injuria sine damno means violation of legal right without causing any harm, loss or damage to the plaintiff. There are basically two kinds of tort.
First, actionable without the proof of any damage or loss, that is, actionable per se. Example, trespass. Second, actionable only on the proof of some damage. Example, defamation. Let's see a leading case law of injuria sine damno, that is, Ashby versus White.
In this case, the plaintiff, who was a qualified voter in parliamentary election, was wrongfully prevented from exercising his voting rights by defendant, who was a returning officer. The candidate for whom the plaintiff wanted to give his vote has come out successfully in the election and no loss was suffered by the plaintiff. Still, the plaintiff brought an action claiming damages against the defendant for maliciously preventing him from executing his voting rights. The court held that the defendant violated plaintiff's legal right, that is, right to vote. So, plaintiff was entitled to damages.
So our next topic is damnum sine injuria, which means damages, monetary loss to plaintiff without violation of any legal right, not actionable because no injury to legal right.
It is not necessary that the injury must be willful or malicious. Let us further focus on the leading case of damnum sine injuria, that is, Gloucester Grammar School case.
In this case, the plaintiff was running a school at a place. The defendant started another school near the plaintiff's school. Due to competition, the plaintiff had to reduce their fees and thus he suffered huge financial loss. The plaintiff filed a suit against the defendant for compensation. The court was held that every person has a legal right to carry on his trade or profession. Here the defendant, by setting up his school, has exercised his legal right and therefore no action can be taken against him, and the case was dismissed.
Next is mental element. The term mental element refers to mental intention of a person. the mental intention of a person could be negative or positive. The act does not make a person guilty unless the mind is also guilty. In tort, following elements are examined to determine tortious liability.
First, malice and intention. Second, motive.
Let's discuss malice and intention in brief.
Malice, which means ill will. In law, malice has two meanings: intentional doing of wrongful act, improper motive. Malice is of two kinds: done wrongfully and without reasonable and probable cause is called malice in law. Act done with ill will towards an individual is malice in fact.
Intention means the objective or purpose. Intention is internal factor, something which passes in mind and direct evidence of which is not available. If a person gets injured by the defendant's act and there was no evidence of intention to injure, the defendant will still be liable.
Motive. A motive is a purpose of doing an act. An act which is lawful cannot become unlawful because it is done with bad motive.
An act which is unlawful cannot be lawful because it is done with good motive. Let's take an example. Suppose Max, a farmer, plants a spring gun on his land to prevent birds from destroying his crops. Ben, a trespasser, enters in his land and gets injured by the spring gun, although the motive of Max was not to injure him. Let's move on to remedy.
The essential remedy for tort is an action for damages, but there are some other remedies also.
First, injunction, a judicial order which restrains a person from beginning or continuing an act which threats or invades the legal right of another person.
Second, specific restitution. It refers to the restoration of a specific thing or condition.
Example of injunction.
After Sam is fired from his job, he threatens to disclose organization secrets to the public. The organization files for an injunction to keep Sam from talking, because disclosure of sensitive company information could result in serious damage. The judge is likely to issue an injunction prohibiting Sam from disclosing the information.
Let's move on to difference between tort and crime. Tort is infringement of a private right.
Crime is act or omission punishable under IPC.
Under tort, there is less serious wrong.
Under crime, there is more serious wrongs.
Under tort, suit filed by the injured party.
Under crime, suit brought by a state on behalf of victims.
In tort, compromise is possible.
In crime, mainly compromise is not possible.
In tort, compensation is paid as remedy.
In crime, punishment is imprisonment or fine.
Let's move on to difference between tort and contract. First, civil wrong which is not breach of contract or trust.
Non-performance amounts to breach of contract.
Vested in specific person against the whole world.
Violation of right of a specific person.
Without consent.
Founded upon consent.
There is no privity.
There is privity.
Here, damages are uncertain.
Here, damages are fixed by party.
That's all for today.
Please hit like and subscribe for more videos.